Hello, and welcome back to Coin Lady channel. Let's discuss where the judge went wrong with her decision from yesterday. Also, this is a matter of opinion, but I find it really obvious. I mean, this is the one problem that everyone, especially the lawyers in the area, keeps coming back to. And I find their arguments to be rather compelling. Even though the verdict was excellent, I feel compelled to discuss this aspect of it. To be honest, I didn't think we'd be able to find all we needed here. But I'll tell you what wasn't on my bingo card: Judge Torres' ruling that programmatic sales do not constitute illegal unregistered securities offerings. When you talk about market participants like you and me buying XRP, it's possible that the transaction takes place on an exchange, but there are other ways that this could be accomplished as well. However, I believe that even Ripple was anticipating that week that it would not go so well, since they had ceased programmatic sales like several years prior, perhaps in expectation of that protect being more challenging from a legal standpoint. On the other hand, you have these transactions at the institutional level, where there is, well, let's just say some uncertainty. What, if anything, does this imply for the XRP-based on-demand liquidity provided by Ripple's? Although David Schwartz currently holds the view that the answer is no, I hope he's wrong about America's openness to new ideas. However, not everything about this is crystal clear. Therefore, I will relay to you the current situation of affairs. But before I go any further, I should make it clear that I have no support of any kind, either financially or legally. Nothing I say should be taken as medical, legal, or financial advice, and you shouldn't buy or sell anything based on what I say. I'm just a fan who likes to dabble with crypto by making films on YouTube, but that's all it is, a hobby. To put it bluntly, if you don't like it, you can leave. Okay, so here's a news item from the blockchain-only publication Ripple. The CTO maintains that the SEC case judgment will not significantly affect OTL-related sales. Judge Annalisa Torres' judgment on XRP as a non-security has raised questions about how ODL-related sales should be categorized. David Schwartz, CTO of Ripple's, used Twitter to explain the situation. According to Schwartz, they are still learning the ropes of this legal situation. They do not have any ODSLS sales that have a US nexus at this time. He did, however, say that Ripple would be fine even if they were unable to undertake sales in the United States. He clarifies that as long as the XRP USD used in their operations is not directly from Ripple, they can continue to conduct OTL business within the United States. This means companies can keep using OTL technology for domestic cross-border payments in the US, so long as they make sure XRP is derived from other sources. Now consider this. And now here's where things may go ugly. In any case, this is something to think about. In that case, XRP, your audio, is the most obviously wasteful component. Now, let's say you work as a market maker. Do you have a lot of XRP? And the value grows with time? Is that something you planned to invest in? Or are you holding on to it because of its utility, only to see its value increase as time passes? Here then is the information that Bill Morgan divulged. So he retweeted what I just told you from David Schwartz, and Attorney Morgan said, "I brought this up a few hours ago. You claim that Ripple is capable of avoiding this issue. The fact is that OTL clients, who are not investing in XRP, are using it for payments, and are not expecting gains from keeping it, are not consistent with the judge's rationale on institutional sales." David Schwartz's response to Attorney Morgan: "The only way I can square it is if the logic is that on-demand liquidity, customers weren't expecting a profit, but that it doesn't matter," highlights a major source of worry. This is exactly what a rational customer should have anticipated before purchasing from Ripple. Towards the bottom of page 18 and first within the age group of 19. But that's just plain strange. Yeah. So, consider that. That's an unusual circumstance, to say the least. The only way I can see to square this circle is to assume that he is correct and that OTL buyers did not anticipate making a profit, but that it is irrelevant whether or not they did so, and that what matters is the expectation of a reasonable consumer when purchasing from Ripple. The problem is that by that time, everything has become so subjective, right? It is strange, David Schwartz goes on to remark, that the buyer is reasonable, but the OTL customer is not. But that's all I can think of right now, and the genuine solution could be something quite else. Before this judgment, I would have assumed that selling to less informed retail investors on an exchange where more knowledgeable investors may also be buyers would be preferable. This decision contradicts the intended usage if it is for personal consumption alone. That's right. This is what I had in mind, anyway. When the judge gave his blessing to the programmatic sales, I remarked that I had missed that square on my bingo card. Right. Exactly. It's the total reverse of my expectations, Schwartz's expectations, and presumably the expectations of the vast majority of you reading this right now. Institutional, well-informed buyers are fine for programmatic sales. Perhaps not. That's a fascinating fact. Let's pretend, though, that former SEC attorney Mark Fagel chimed in to respond to Schwartz, arguing that the ruling reversed the intent of the securities laws by affording protection only to sophisticated institutional investors with access to information, while ordinary investors buying on exchanges who heard the court were too stupid to know what XRP was. The market could be full with smart people who want to acquire a lot of large cap coins and hold them for a while to gain exposure to the asset class. I simply wanted to add that, because I understand what he means, I was wondering if they were familiar with Ripple. Okay, most first-time XRP buyers aren't even American, they have never heard of Ripple. They see what other developers are doing to improve upon the XRP ledger, or they have a general understanding of how technology works in general. But if we reverse the motivation here, my main issue is that he seems to be fine with less liberties when it comes to purchasing and selling decisions in markets. If you want disclosures to be made, that has been my position. No problem. Demand that all necessary disclosures be made. Okay. Don't assume to say whether or not a certain item is sellable. That's what I think every time I have to deal with accredited investor garbage. However, consider the response provided by David Schwartz, who is both an attorney and a lawyer. I agree with him wholeheartedly, he's making an excellent point. He laments that you didn't inform Congress of this realization in the 1930s. Nearly every corporation operating in this field has been saying for years that it is time for Congress to establish new regulations to meet the goals of these laws. Exactly. What has already been voted on is what you examine. The stage has been set. The judge, Torres, is probably kicking herself for not considering this at the time, but is now making sure her decision is consistent with the law as it currently stands. And lawyer Frankel has a view I don't agree with, but because I believe he is being intellectually forthright, I'll share it. He claims that the laws were deliberately written to be flexible. Insider trading wasn't even something lawmakers considered. Although there is no express statutory prohibition against it, the SEC and the courts have interpreted the legislation to make it illegal. And so David Schwartz retorted, there's a delicate line between adjusting current legislation and inventing new law. Crypto tokens fall under the area of investment contracts and no other type of securities. To determine if a particular offering constitutes an investment contract, it is necessary to examine the specifics of the deal at hand. I agree with him completely. Further, he clarifies that some types of native crypto tokens, namely tokens that incorporate legal rights to things like redemption or participation, can be classified as securities. This, then, is the very meaning of safety, as I have stressed before. Also, digital tokens and other cryptocurrencies aren't included. I've heard him say similar things, so I know he gets it. All okay, but what about the motivation? You are making a lot of assumptions, though. Moreover, it does not adhere to the legislation as it is currently drafted. Therefore, I don't think the argument holds any water. David Schwartz is right on the money, but I don't think so. The fact that everything seems to be backwards here is, to put it mildly, peculiar. I even heard lawyer Deaton mentioning this in yesterday's live webcast. Indeed, it still appears that there will be a great future for Ripple, which is what we desire. Please be aware that said service will be made available via XRP. No matter how you slice it, the issue remains, can it survive in the United States? The likelihood of a positive outcome increases. David Schwartz says so. He's probably right, but I don't think everyone's on the same page about how that will play out. So, I'll keep an eye on this to see if it mandates a shift in the OTL flow paradigm. You shouldn't use my advice to buy or sell anything because I'm not a financial expert. Please like and subscribe my channel. See you in the next video. Bye.